discussing the new updates for asylum seekers as well as other live US immigration updates. We'll be taking your questions also soon. So make sure you are ready with your questions. I'll be sharing my screen so that we can get started. If you guys can see me and hear me well, please type in USA. Type in USA, or you can just drop the emoji of the US flag in the comment section, and I'll be assured that you can hear me and see me well. I'm sorry, I have a cold that just developed yesterday, so my voice sounds a little funny. If you can hear me and see me well, please type in USA across the platforms so that we can get started. We haven't been live for the past couple weeks. 2 weeks ago, I was in Ghana on Friday, and last week, Friday, I actually came back, but I could not do the live session. So we missed just 2 Fridays. We hope we are going to continue in our consistency to come live every Friday at 1 p.m. Please drop USA if you can hear me well and see me very clearly, please, guys, so that we can go on and jump into what we came to do. We have a lot of interesting discussions we are going to have a lot of interesting discussions today. Okay, oop, let's start with the asylum EAD. All right, some of you are already aware that we've announced it on our social medias when the rule was published. So we're going to talk about the rule today. The rule was published, a new rule which will affect asylum applicants. It was published in the Federal Register, which is the daily journal of the US government. So when there's going to be a new rule, a new rule, they publish it in there to serve as notice to everybody. Okay, so this was published in the Federal Register notice, and this rule was published as a proposal, and so it's not a final rule. The rule has not been finalized. We are currently in the comment period, and at the end of this video, I will be telling all of us how to submit comments. If you are interested in opposing this rule, submitting your opposition to this rule. Guys, I went on to the Federal Register. I already submitted my comments to oppose the rule, and it's just 145 comments that have been received so far. You guys know that there are over 1.4 million asylum applicants. Over 1.4 million. There's a lot of them. In immigration court, there are even much more. Even with USCIS alone, there are 1.4 million cases, over 1.4 million cases that are pending. So I would have expected that there should have been, if for nothing at all, at least 2 million comments so far. Well, maybe people are gearing up because the comments period is open and will close on April 24th, 2026. So perhaps people are waiting maybe in March to submit their comments. I'm hoping that's the case. But 145 comments so far is not encouraging. You have to submit comments to this to show that you oppose the rule. That is, if you are opposed to the rule. Okay, we're going to be discussing what the rule entails and why you should oppose it, even if you're a US citizen or you're a green card holder and this does not affect you. So long as you're in the United States, you should oppose this rule because it's likely to cause a lot of problems if it's implemented or if the rule becomes final. Okay, now when you submit comments, people ask me, does it matter? Does it have any impact? Yes, it has impact. When you are identifying some type of conflict in the rule between what the rule is saying and what laws we currently have, if you show that the rule goes against congressional intent for creation of asylum, if you are able to raise some constitutional issues or you provide economic impact evidence. I mean, when there's a rule that says that asylum applicants likely will not be able to work. I mean, if you read proposal, the goal of this is that asylum applicants are not entitled to work and should not be allowed to work, so that this will disincentivize people who are trying to come into the US to apply for asylum. Because according to the government, many people come apply for asylum so that they can get work permits. They know that they don't have a valid claim, but they will apply for the asylum, and then they know that okay, asylum can take 10 years, it can take 15 years, well, well, 10 years, 7 years, 6 years, and so they're able to work during that time. So the goal is that, look, stop them from working so that um people will not find it fun to make up fake asylum claims. But the problem is that it impacts other people who have valid asylum claims, and just impacts the whole United States in general, because these people are going to be living amongst us. And if you have millions of asylum seekers who cannot apply for work authorization, then how are you expecting that they will survive? How are you expecting that they'll survive? I mean, do you want them to commit robbery or just start committing violence because they don't have a means to earn money? Okay, so these comments are very important. If you submit the comments, then it could help when there's litigation, because judges could review the comments that were submitted and see how the government um, applied those comments in their final rule that they come up with. Okay, so now let's go on to the rulemaking. We're just going to go to the portion that um, I think this is about 200 pages, but the executive summary gives us a very nice, clear breakdown. We won't go over everything here. We'll just go over the summary of the major provisions of the regulatory action. That's what we're going to be looking at today, in the first part of this video session. Okay, so the first major rule or the major proposal is that the government is planning to amend CFR, the Code of Federal Regulations, and I'm going to explain it. This Code of Federal Regulations, it has to do with the fact that DHS, they are proposing to align um, its criteria for determining when an asylum application is received and complete. Okay, they are going to align this more closely with the general rules governing immigration benefits requests. Okay, for many immigration benefits requests or many immigration applications, like a green card application, when you file a green card application and you don't, for example, include the correct fee, then USCIS will reject your case and send it back to you. When USCIS rejects your case and sends it back to you, you don't retain a priority date. It means your case is not in queue. But for asylum, what happens is that if USCIS rejects your case and they don't send it back to you, usually within 30 days, then your asylum application is deemed complete. And so you retain a date of having submitted your case. Now, the first proposal is that they want to remove this automatic completion of an asylum application, even when the application is not complete, just because USCIS failed to return it to the applicant. Okay, so that's the first proposal. Obviously, it's going to go against many asylum applicants, because when you are filing your asylum application, you should make sure that you are using not just asylum, the designated filing location, valid signature, whatever fee you have to submit. If you don't do these things and USCIS reject your case, even if they don't return it to you within 30 days, you know, your case does not retain a filing date. And it's relevant because asylum, you need to make sure that you have submitted your asylum application within 1 year of entering the United States, or there are exceptions there, but generally within 1 year. So if your application is dated after the 1 year period of you entering the US, or it's dated way after it should be dated because you didn't do something right and so your case was rejected, then you're going to be in hot waters. So that automatic completion by USCIS, even when your application is wrong, if they do not return your application back to you in 30 days, is going to be removed. That's not good at all. I mean, so you get that number one major change. Number two, biometrics. DHS is saying that they want all applicants for C8 work authorization, including renewal requests, to submit biometrics. C8. Let me explain that every body who's applying for a work permit in the United States, all immigrants. And you guys know, if you're a US citizen, you don't need to apply for a work permit. If you're a green card holder, you don't need to apply for a work permit. If you have some type of visa that has a work authorization incident to that visa, you don't need to apply for a work permit. For example, an R1 visa or an L1 visa. There's some of the visas that for an H1B visa. These are some of examples of visas that already have work authorization incident to the visa. The visa itself is a work permit. So when you come, you don't need to apply for a work permit. But for every immigrant who's in the United States who wants to apply for a work permit, either based on marriage, based on abuse, based on being the victim of a qualifying crime, there is a code that USCIS will use. Now, for asylum, if you have a pending asylum application, you tell the government, I can apply for a work permit based on my pending asylum application. And the code you use is C8. C8 means that they are going to connect you with asylum applicants and your case will be processed along those categories. And so for biometrics, they now want all applicants for the C8, pending applicants, even if you are doing a renewal request of your work permit, you need to submit biometrics. If not, then your case will be denied. Obviously, they want to keep checking. Have you gone and committed any crime? I'm sorry, are you using false identity? Just biometrics has to do with your identity. They want to see if there's any hit in the system, if there's any negative information that they can get from you running your biometrics. Okay, because they use or they double check your biometrics against a lot of databases, including criminal databases. So they want to be able to run these vetting and screening periodically. So there's going to be second change biometric requests for even renewal, people who are renewing their work permit applications under asylum. And then the next thing is that there's going to be an extension of the 180-day asylum work permit clock to 365 calendar days. Okay. Currently, what's happening is that if you enter the United States and you submit an asylum application, you cannot immediately apply for a work permit. You have to wait for a 150-day period before you can submit your asylum application. And then USCIS can only give you a work permit after 180 days of submitting your asylum application. So your clock starts to tick once you submit a proper asylum application. 150 days after you can submit. So now they're saying that instead of that 150-day period, you are going to wait 1 whole year. You submit your asylum application on February 27th, 2026. Then you can only submit a work permit on February 27th, 2027. Okay. So under the proposed rule, asylum applicants would be eligible to they would be eligible to apply for work permit 365, 1 whole year from the date the asylum application is received. And this is really concerning, of course, because you bring people who are fleeing persecution, who are running from their home country. Sometimes they come with, in fact, 90% of the time they come with nothing. They've sometimes crossed countries and rivers, and they've lost everything. And so they have to come and sit here for 1 year without working. I mean, are we trying to turn people into armed robbers, or we're trying to turn them into angry, violent people? If we're in a society and some people are deprived of working for 1 year, what are we trying to do? Okay, so that's one of the big problems. That is one of the big, because people are going to likely try to resort to other means to take care of themselves. Uh, Many asylum seekers work really hard, they contribute to their communities, so this rule is quite problematic. Now the next change under number two c recommended approvals. In the past, DHS, before they would finally adjudicate your asylum application, they would say the application was recommended for approval. But USCIS stopped that practice some time ago. It no longer issues recommended approvals as a preliminary decision for affirmative asylum adjudication. So, they would usually do a first stage, like, oh, this person has been recommended for approval, and then they'll continue with the pending all final adjudications like vetting and background checks before they'll finally issue the final approval. That is no longer in existence, so they want to remove that language in the Code of Federal Regulations to align with current practice. Number four, processing time frames. This is another big one. USCI or DHS, what they're saying is that now they are not going to be restricted to completing work permit applications within 30 days. Currently, they have to complete initial asylum work permit adjudications within 30 days. And they're saying that no, they don't want to be constrained by such a timeline, and they should remove this. They're proposing that they remove this time constraint from the Code of Federal Regulations, so that they will extend the processing time frame of initial asylum work permit from 30 days to 180 days. So now initial asylum applicants will no longer wait just 30 days to get their work permit. They have to wait for 6 months to get their work permits. Now, if your asylum application or your work permit was submitted, C8 work permit application was submitted before this effective, before this rule becomes final, then you will not be impacted by the new 180-day rule, processing rule. Number five, five, 2.5 ineligibility grounds. This is another proposal, major proposal. DHS, what they're saying is that where there is reason to believe that an immigrant is not eligible to receive asylum because they have one of the bars, then um, you are not going to get a work permit. Okay, if you have one of the bars, you are not going to get a work permit. Let's look at some examples of certain things that can make you ineligible for a work permit under a bar. For example, if you've been convicted of a serious crime, particularly serious crime, we're looking at things like an aggravated felony, um, uh, things like um, murder, things like rape. Okay, those types of things are problematic. And if you have those, where there's you guys listen to the standard, where there's reason to believe, you see. So if there's any reason to believe that you are barred from the grant of asylum, but reason to believe is a legal standard, they'll look at certain things to see that, oh yes, there's reason to believe this person may be barred or may be ineligible for asylum because they've committed a serious offense, then you will not get a work permit. Then 2F, the next proposal is that DHS is proposing to the effect. Okay, so exclude from initial work permit application if your asylum application is denied by an asylum officer or an immigration judge within the 365 calendar day waiting period. Okay, so while your asylum application is pending for the first year, if your asylum application gets denied by month 8, you cannot get a work permit after the 1 year rule because your asylum application has been denied. And so your work permit application will now no longer have any footing to stand on. It will not have any footing to stand on. Okay. All right, let's go here. Let's continue with that. Okay. Now, unless of course the no, that's fine. Yeah. Yeah, okay. So you will not be able to apply for the work permit because your application has been denied. Then the 2G is 1 year filing deadline. We already mentioned DHS, as you already know, if you come into the US, you should file your asylum application within 1 year of entry. If your if you entered let me go back. Any immigrant whose asylum application is filed after the effective date of the final rule and more than 1 year after you enter the US. Okay. So once the rule becomes final, if you file your asylum application more than 1 year after you enter the US, let's say you enter the US on January 1st, 2026, you have until January 1st, 2027 to submit your asylum application generally. Majorly, you need to make sure you've submitted your asylum application. If you don't do that, then you submit your asylum application on February 2nd, 2027, even though you entered January 1st, 2026, you will not be eligible for a work permit unless you are determined to be exempt from that 1 year filing deadline. You have an exception to the 1 year filing deadline, such as you have exceptional or extraordinary circumstances or changed circumstances, or unless the immigrant is under USCIS's initial jurisdiction as an unaccompanied um, alien child, UAC. Okay, illegal entry, that's under 2H. So DHS is also proposing to exclude these people from the C8 work permit eligibility. Anyone or an immigrant who enters the United States, if you enter the US without inspection, without a visa, on or after the rule becomes final. Okay, so if you enter the US without a visa, like what we call entry without inspection, you cannot apply for a work permit under asylum unless within 48 hours of entry, you express to an immigration officer that you intend to apply for asylum, or you express to an immigration officer that you are afraid of being persecuted or you're afraid of torture. There are some exceptions there. But I guess the meaning of this rule is that if you enter without inspection, and then, some people will enter without inspection, they figure that they are already looking to enter the US. Then 6 months later, they come and apply for asylum. The government is trying to say that, well, if you entered without inspection, you should have told us very early on that you are actually coming to seek asylum. If you don't say that, then you cannot apply for asylum unless you also or you can establish good cause for your illegal entry. You have to establish good cause for your legal entry, or you were an unaccompanied alien child. Okay. Now, the use of derogatory information, this is under number 2I of the proposed changes. DHS is proposing that they will prioritize asylum applications for adjudication if USCIS finds derogatory or negative information during the adjudication of your work permit. So, if they are reviewing your work permit and they find any negative information, you see, they've already proposed that your work permit application should be accompanied by biometrics, even renewal. And so once they adjudicate and they see that, oh, this person who has applied for a work permit has just been convicted of domestic violence or petty theft or any crime, or there's just something negative on your file, they will prioritize your asylum application to adjudicate or to decide upon it so that they can quickly deny you where they have to. Okay, now we have 2J, they are proposing acceptance of initial EADs when the average processing time frame for affirmative asylum over. Okay, so this is a little complex. Let me break it down here. USCIS or DHS is saying that when the average processing time frame for asylum over a 90-day period, so for a 3-month period, okay, if the processing time frame, so they'll be studying, let's say between March, April, May, let's say between March and May 2026, if they realize that processing time for asylum is more than 6 months or 180 days, then they are going to pause accepting new work permit applications based on asylum. Then they will only they will only continue, or they'll restart accepting work permits once the processing time goes below 6 months or below 180 days. And USCIS themselves, you'll see that they said in the somewhere in this uh, rule that, or this proposal, that it's likely going to take up to about 173 years for processing times to go below 180 days. Between 40 years and 173 years for processing times for asylum to go below 180 days. And this will depend on how impactful this new rule is. If there are less asylum applications, then that means that processing times can reduce. Okay. So there's going to be a pause and restart of acceptance of initial work permit applications. All right, let's go on here. The next thing they are proposing, we're going through all the major changes. Let me see, what did I skip anything here? The next change is number 3, I believe. They're going to amend another regulation. They are proposing to clarify and consolidate the requirements for requesting a C8 work permit renewal, and they specify that immigrants who are applying for renewals must also submit biometrics. They're amending number 4, another regulation, termination. Under the proposed rule, they will terminate your work permit if immediately your asylum application is denied by an asylum officer, unless, of course, your case is referred to an immigration judge. Okay. So once you go for your asylum interview and your case is denied, your work permit now becomes terminated and invalid, unless the asylum officer refers your case to an immigration judge on the date that is 30 days after the date on which an immigration judge denies an asylum application, unless you appeal. So they will terminate your asylum work permit 30 days after the immigration judge denies your application. Because remember, when the immigration judge denies your application, you have 30 days to appeal. So on day 30, they will, after day 30, your work permit terminates unless you file an appeal, timely appeal to the BIA, Board of Immigration Appeals, or your work permit for asylum will be terminated immediately following the denial or dismissal by the BIA of an appeal. Okay, so 3 levels of when your work permit will be terminated under asylum. Number 1, when your case is denied by an asylum officer. 2, when your case is denied by an immigration judge and you don't file an appeal. And 3, when your case is denied by the BIA. All right, the next one is that DHS is proposing to remove reference to recommended approvals. I think we already mentioned this, and yeah, and then application. Okay, yeah, recommended approvals are going to remove that preliminary start. So this looks like it's a repetition. And then the next one is that number 6. Under the proposed rule, issuance of a work permit for asylum applicants um, will be discretionary. Discretionary means that even if you qualify, the officer can use discretion to deny your application. Okay. So it will be discretionary. The grant of a work permit under asylum will be discretionary under this proposed rule. If it becomes final, these rules will likely become final. Sometimes they'll amend certain things in the final rule. We'll wait to see, but generally, you can expect that this will become final. And then technical and conforming updates to the proposed amendment. Um, yeah, they're revising their regulations to remove outdated language. They are replacing references to the commissioner with USCIS. Okay, so that's the last thing. Okay, now let's see. Let's move on. We have a lot of other topics, but let me talk about how you can submit a comment. Let's talk about how you can submit a comment to oppose the rule. Let me show you guys how you can submit your comments, please. And please make sure that if you share this, let people have to submit comments. It's not just about making noise and just crying in our rooms. Immigrants have to learn to advocate for themselves by doing the little that they can do. Okay, so I'm going to share this screen with you guys here, and then we just go through really quickly how we can submit comments. Let's see what I can do here. Okay, now look, this is the Federal Register notice, or yeah, in the Federal Register. You go here. I'm going to likely share, will likely share the docket number with you, but if you Google employment authorization reform for asylum applicants, you will find in the Federal Register. You will find the exact one in the Federal Register. We'll share the link, and I will try to share a video on this so that you can get the process of trying to submit a comment easily. And it's right on the top there. Submit a public comment. This is it. You just post your comments there. These days, ChatGPT helps a lot of people to draft a lot of things. You don't want to think too much. You can just use. Let me see if I can have. I can have. I think I was okay. So I'm going to submit a comment again. Let me see if it's going to work because I already submitted a comment. This is for illustration purposes. I respectfully oppose DHS's proposal to pause acceptance of initial EAD. Blah blah blah. Just I oppose. And if your comments are, I'm just going to submit as anonymous. If your comment has legal, economic implication, policy implications, then it's likely going to be taken seriously. So you have to bear that in mind. Um, Many asylum seekers work without, they work really hard, and without work authorization they may be unable to support themselves or their families while waiting for a decision. This can create unnecessary hardship and instability. It allows asylum seekers to be self-sufficient, contribute to their communities, and maintain stability during the adjudication process. So it goes on and on. So we can just submit this. You guys see, it's very simple. It's not hard at all. And then you click submit, okay? And then it gives you the comment tracking number. And you can use it to just track your comments to see whether it's been reviewed and publicly posted or whatever. So there you have it. You should submit your comments to this rule to show that you oppose the rule, please. And I'm hoping that many of you will submit comments. At least 1 million asylum applicants. If the US citizens don't care, you should care because this impacts you directly. All right. There's a lot of other things I put down. We wanted to talk about arrest of refugees. I have everything here. I'm just, you guys could tell I have a bad cold. I'm exhausted already. Let me see. There's another topic I put. Okay, let's talk about this current, this trending issue, and then we can call it a day. We can talk about the other things hopefully on another episode. Um, there's CNN is saying that the Trump administration is considering letting banks verify the immigration status of people before they can open accounts. Um, Under current law, non-citizens are able to open bank accounts, but I'll tell you, practically speaking, you'll have a lot of um, immigrants those who don't are undocumented. Some of them don't even use the bank. They get paid cash, sorry, and they keep the cash on them in their homes and in other safe places because they just don't want to be bothered with the bank and sometimes a lot of formalities. But there are some who are able to, there are some banks who are able to accept undocumented immigrants. Usually the banks are concerned with, just know your customer KYC. I actually worked in a bank when I think I did my national service at a bank in Ghana. So, and I did retail. So, yeah, you do the KYC. And the bank, remember, they're just interested in the money, really, and just identifying you. Money laundering issues, just identify that you are who you say you are. They're not interested in your status because it really doesn't have too much bearing on what they're doing. So they want to know who you are, so your name, date of birth, your IDs, if you have a social security number or an item number. And for many states, you can get an item number. If you're a resident in the state you are living there, you can get the individual taxpayer identification number to pay your taxes for purposes of paying taxes. Um, so the common acceptable forms of ID by banks, and this varies by the bank or the type of bank. We have foreign passports, your driver's license, ITIN, social security number, proof of address. It could be a utility bill, lease. So the banking laws usually focus on identity. They are not usually focused on your immigration status. And so now this is going to be, if it's implemented, CNN says that this is likely going to be implemented through an executive order. They just want to make life very unbearable for immigrants who are undocumented so that they leave. The goal is for people to self deport. That's really the goal of all these changes and rules that the Trump administration is coming up with. So just keep an eye on this one. Let's see how this evolves. Okay. Right. Let me see if we have a few questions as to whether this bank rule will be implemented. We don't know. Industry players are saying that this will be very difficult to implement because how are they now going to check the status of all current clients and new customers? That's going to be really hard for them. But we'll see what they say, how this plays out. All right. Let's see here. Yeah, let me see if we have any questions and then we can take those questions. Okay. Raz Yadav says, sorry to disturb you, but what about the EDV lottery paused? No, that's not a disturbance at all. It's a very good, relevant question. Yes, the diversity visa lottery has been paused. And these people, they have just literally paused the diversity visa lottery program, which allows up to 50,000 people to immigrate to the US annually. They know that the diversity visa lottery program is very time sensitive. And so if you are pausing it, they know they cannot just stop it by through these agency actions and orders like, oh yeah, we Department of State just announced on their website, I believe was December 23rd, 2025, that yeah, we're pausing issuance of that diversity DV 2020. Is it 2026? Yeah, they mentioned that they are, I can actually pull it up. They are just pausing issuance of the diversity visa lottery program, issuance of visas under the diversity visa lottery program. And it's just a smart way or a sly way of saying that, yeah, we don't want this program to continue, but we know we can't cancel it. We cannot cancel it. So what we will do is we will just block issuance. Okay, I found it. December 23rd, 2025, diversity visa issuance updates. They said they are no longer effective immediately. Department of State has paused all visa issuances to the diversity visa lottery program. So, I mean, it does not look like this program. I mean, unless there's some litigation. Let me just share my screen here. Unless there's some litigation that happens, and a federal court says that they should lift that ban. It has been paused. Look at that. It's been paused. They've paused all visa issuance to the diversity immigrant visa applicants. And this is the latest. This is the latest they've released on the diversity visa lottery program. And so there's no new updates there. Um, there's no new updates there. No more visas under the diversity visa lottery. And when they say they have paused, look at the language they are using, paused. So we don't know when they will unpause. So we keep our ears out and then, on the ground and see what happens next. All right, let's see. Guy Christopher Carter says this proposed rule is absurd. It is cynical toward the plight of refugees escaping criminal and state violence. It encourages criminality and dishonesty. It also runs counter to reforms being enacted in the EU. Thank you for your contribution. Absolutely, it's very dangerous. It's just mind-boggling that somebody could sit down and come up with all these rules. And I told you guys, the goal is to just stop asylum seekers from working, because they were very clear in the announcement that was published on the USCI's website. It said that aliens are not entitled. That's the language you use. We don't use that language, but pretty much immigrants are not entitled to work permits while their cases are being processed. And so all the rules are geared towards making sure that people will not be able to work while their cases are being processed. Very vile, and I'm not sure I understand what the goal of all of this is. Okay. Um, all right, guys. I think we've answered a couple questions. Let me see if we have some questions on TikTok before I pull up the next question. Please make sure you have followed our page, AK Poku Law, across all social media platforms. Kinsey Imperial says, can someone with a pending asylum and valid tourist visa change status to H-1B visa? Yes. So long as you have, it's when you say, let me explain. The pending asylum, you cannot change status. A pending asylum alone cannot make you change status. A pending asylum is just that, it's a pending asylum. It doesn't give you lawful status. But if you have a valid tourist visa, even a valid tourist visa, a visa itself is just an entry document. A valid visa doesn't help. It's actually your I-94 that controls whether you can change status. And so if you have an I-94 that is still valid, it's not expired, then you can change status from B to H1B. From B to H1B. So yeah, there you have it. Okay. All right. All right, guys. Well, thank you so much for joining us. And guys, we have a special guest, I believe, next week. Um, we'll have the former immigration judge, He'll be joining us next week, so make sure you're here. We couldn't host him in February, but he will come twice in the month of March to discuss, what you should know. He was an immigration judge, Trump, Let's Go, hundreds of them. He's one of them. So he has a lot of insider tips. We've already done 2 live video sessions with him. If you haven't watched, go onto our YouTube channel and watch those videos. We discuss a lot of things immigrants must know before they step in immigration court, as well as other pertinent matters. Thank you all so much for joining us. I'll see you guys again in our live session next week. And until then, take care. And of course, if you need our help, please make sure you contact us, AK Poku. And guys, I'll tell you, there's a lot of scam going on. There's a lot of people who they think that, oh, this is a good season to impersonate or to act like they are particular immigration attorneys or particular law firms. So you have to be very vigilant. You need to, if you are looking for us, please don't go anywhere. Just make sure you're coming to our verified social media platforms, AK Poku Law, or you can Google us, AK Poku Law, and you'll find us everywhere. You are free to call. You can text. You can WhatsApp us on 802-780-0564. We do consultations on video, on the phone, on WhatsApp, in person. It doesn't matter where you are in the world. It doesn't matter which state you're in. We'll be able to help you, and we handle all your immigration matters. It's been a pleasure being your host today. I'll see you guys, being your hostess today. I'll see you guys hopefully next week. Take care and have a great weekend, everyone. Bye.